Hello, lawyer, and all law students who are listening. I'm Catherine Mason. I'm the director at Cambridge Law Studio. I was also one of the founders of the TOLS exams in legal English. Welcome to our quick legal vocabulary class. Burden of proof. The burden of proof is legal English from a court case. These words are used in the legal process in both criminal cases and civil cases. For example, in a criminal case, the burden of proof is always upon the prosecution. So in your first language, if you think about a court case, a criminal case, the lawyer prosecuting has to prove everything. He or she has the burden of proof. So guess what the translation might be into your first language, and then when the video's over, see if you're right. In ordinary English, the word burden means something that you must carry, but it's something very heavy. Burden is usually a very negative word. A burden is a problem. The word proof means something is established as true. It comes from the verb to prove. So when you put the two words together, a burden is something that's a problem. It's something that's heavy. And proof is difficult. It's establishing something as true. So you can see that burden of proof means the problem of having to prove in court that something is true. So what does burden of proof mean? It means that in court, for example, in a criminal case, the prosecution has the problem of establishing what is true. The accused person does not have to prove anything to the court. Proving that is the prosecution's job. So in reality, if you've seen a criminal case, of course, the accused person always tries to prove their truth, but it's the prosecution's job to get the real proof, the real truth, and that's what the burden of proof means. Here's an example. This will be a difficult case. As the prosecutor, the burden of proof is on me, and the police did not give me enough information for me to win in court. And this is very typical, I think, in criminal cases. Proving something, especially when no one saw it, is incredibly difficult. And in England, quite a lot of criminal cases never actually come to court because the prosecutors, although they think the accused is guilty, they know that because they have the burden of proof, they don't have enough information. So it is something heavy. It is a problem. In civil cases, for example, a breach of contract case, it works in the same way. In the UK, we name the two parties the claimant and the defendant. The burden of proof is upon the claimant to establish facts as true. The defendant does not have a legal duty to prove the story is untrue. So it's a little bit easier usually in a civil case like a breach of contract to produce proof, to establish facts, because you've usually got emails or WhatsApp messages or minutes of a company meeting, and that establishes truth. You have it in writing. Unfortunately, Criminals usually don't write down what they're doing or email people what the plan is, so you can see the burden of proof is a little bit easier in civil cases. And before we go further, those two words, claimant and defendant, in the United States, they use the old word plaintiff, but we say claimant. We had a modernization about 26 years ago. So we have the claimant and the defendant in a typical civil case. Congratulations! You can now use the words burden of proof like a legal professional. Here's something for you. If you want to practice these words and more absolutely free, please do download our free PDF, which is part of our A to Z of Business Law book. The link is in the description below. Please click on it, do your homework, and bye for now.